Defendant's convictions following a second jury trial for first-degree burglary and related crimes stem from a June 18, 2001 afternoon home invasion in which defendant, accompanied by at least 2 other men, unlawfully entered a home on Lord Avenue in the town of Brunswick, assaulting and shooting one of the occupants. At the first trial, the jury had been unable to agree on a verdict and a mistrial was declared. At the second trial, the victim testified that the defendant, whom he identified in court, entered his kitchen, shoved him against the refrigerator and then to the floor, placed a loaded gun to his head, threatened to kill him, and struck him. In response to the victim's resistance and repeated efforts to stand up and move the gun away from his head, defendant eventually cornered him in the bathroom, shot him in the arm, and fled with his accomplices to defendant's vehicle, pursued by the victim, who successfully recorded all but the last number in the license plate before it sped away, and reported that information and descriptions of the vehicle and shooter to police. One of the defendant's accomplices, who had not testified at the first trial, testified that he, defendant, and defendant's cousin went to the victim's house planning to commit a burglary for drugs, and that defendant had hit the victim and shot him before they fled in defendant's car. Defendant testified that he followed the others into the house so he would be able to make drug purchases there on his own in the future, but denied any role in the shooting or assault. Testimony which was impeached on cross-examination by his testimony at the first trial that he never entered the victim's house but waited outside. Within an hour, around 5 p.m., defendant was apprehended in the city of Troy while driving his vehicle, which was registered to him and insured in his name, and taken into custody by the state police, who provided Miranda warnings and transported him to their barracks. During periodic questioning, defendant denied involvement in the home invasion, but admitted that he was the only person to drive his car that thereafter in the afternoon, and he had no alibi after approximately 3 p.m. At approximately 10 p.m., while defendant was being questioned, the victim viewed a photo array and indicated that the picture of defendant looked like the assailant, but that he didn't want to say exactly it was him, and he saw him in person. Informed shortly after 10 p.m. that the victim had not made a positive identification from the photo array, state police investigators, aware that defendant was on parole, decided to postpone charging him for these crimes, which were contained in an unsigned felony complaint. Instead, they continued to detain defendant and contacted his parole officer, hoping to continue his detention based on a parole violation which they further investigated. Although there was no outstanding parole warrant, defendant's parole officer came to the state police barracks, obtained defendant's keys, searched his residence, and, upon discovering certain weapons and a beeper, possession of which constituted a parole violation, issued a notice of parole violation and signed a warrant for his arrest during the early morning hours of June 14, 2001. This led to defendant's arrest on parole violations and transport to the county jail, where his clothing and shoes were secured by jail personnel. Although not admitted into evidence at his first trial, at the second trial, the people submitted testimony that subsequent DNA testing on these items indicated with near certainty that they maintained or contained blood from the victim and defendant. The next day, June 20th, 2001, a lineup was conducted at which the victim immediately identified defendant as the shooter. On June 22, 2001, pursuant to a bench warrant, defendant's clothing and shoes were taken from the jail into custody by the state police. A sealed indictment was handed up approximately 1 month later, containing the offenses for which defendant has been convicted and sentenced to concurrent terms of imprisonment. Those are no fooling around take. $150.